(2017-294) State of Arkansas versus Chris Jackson.
Morning, Your Honor.
Mr. Jackson, let me just check. We have you down to appear here today. All right. That answers the question. Court's making the appointment of the Public Defender's Office with regard to 2017-294. And I'll make the appointment on the revocation if it's going to be, if it's gotten filed, otherwise you can tear that one up. There's the appointment of the public defender. He's already been arraigned on that. He entered his plea of not guilty on August 3rd. Arraignment and has the scheduling order in place. And today's date was just to determine representation of counsel. All right. That's been established by the appointment of the Public Defender's Office. Your next appearance in court, Mr. Jackson, under the court's order. Next time you'll have to be in court is November 16th.
Yes, sir.
Okay. Now, as I told you last time, you need to stay in touch with your attorney, make appointments, and get in there to see.
Absolutely.
And the court's ordering you to do that. That's your job.
Yes, sir, Your Honor.
All right. You may be excused at this time. 2017-308 State of Arkansas versus Zachary Sisk. I think we were just trying to make sure that Mr. Sisk, there's a scheduling order in effect. I'm checking on the kind of the status of the case. The Public Defender's Office is representing Mr. Sisk.
Yes, Your Honor, we are.
Are there any issues to be raised today?
No, Your Honor, there are not.
Mr. Sisk, your next appearance in court will be November 16th.
Thank you, Your Honor.
You may be excused. (2016-314) State of Arkansas versus Alicia Kirby.
Judge, Ms. Snow is here. Oh, there she is. I thought she would have stepped out. This case is one, I've spoke with the co-defendant's attorney in this, Andrew Bailey. The defendants are indicating that they want to be tried together. They're now husband and wife, and I know the state has a say in that, but Mr. Bailey wanted to speak with his client first. The issue that may present is that one, Mr. Snow is on the Division III. I believe he's set for trial in October. And so if we do get a resolution where we try these together, we'll have to pick a horse that we're going to ride to trial, I guess, as far as division-wise.
We have it set for Monday, but this case for Monday. But, all right. Are we trying to move it?
Judge, I would ask to continue it on the defendant's motion. It's the exact same set of facts. I think if there's a case to be tried together, this would be one. Because
what's the defendant's name?
John Snow is the co-defendant.
Your Honor, since there's a date already set for Mr. Snow on that division's docket, the state is not saying we agree to try them together, but if we're going to move it to a day, I'd rather move it to that October date so we don't have to be so far down the road.
The defense is asking for the joinder, actually.
Yeah, the state is not agreeing to that at this time, Your Honor.
And that's one of the issues, is it's not exactly right to for us to make that full petition, because Mr. Bailey will have to make his client aware of some things that my client's okay with. And her husband was standing there when we were talking, and it sounded like they were both okay with it. But me and Andrew both, I feel like, Mr. Bailey need to put a motion together for both parties to ask if they be joined together, not just me asking to join him.
So all I should do today then is transfer Alicia Kirby off from the Division 3 to the Division 4 to the Division 3 docket? Is that what's being asked?
State has no objection, Your Honor. It's our case regardless, so.
That's fine, Judge, or we could just simply continue ours and see if we can work out to join these, because we may not, if they're not gonna get joined, there's no need to transfer the division. But to me, it's 6 one way, half a dozen the other, though.
Well, what, well, if it's not being asked, if there's not a request on either side to transfer, the request then is to postpone this trial.
Correct, Your Honor. I think that would, at this point, until we get Mr. Snow's counsel to agree to join that motion to combine these trials, I don't want to.
They're all in agreement if the state is.
Okay. I don't want to transfer it to Division 3 and then the motion to join not be granted, because I think we've just moved it unnecessarily. But I spoke with Mr. Bailey this morning. He was going to get Mr. Snow in his office and file a duplicative motion in both divisions in both cases. If we could continue Mrs. Snow to this court's October date, I think that would suffice for today for what the defense is trying to do, and then let us get with Mr. Snow's attorney and get with the state to see if we're going to agree to join and try these together.
Let me check. The original violation occurred in February of 2016. Filing of the case
Wasn't arrested until September.
was in September, at least with regard to Miss Kirby or Miss Snow, was
Both arrested.
in September of 2016. So this is an old case. And,
Judge, I believe that the defense is taking quite a bit of amount of time. I know that I've taken all the time since I've been involved, and that was back early this spring, because it was originally set for trial. It was into the process when I got involved, I'll say, and so I know I've continued it several times on our time. So I think that speedy trial shouldn't be an issue if we set it for the.
So I'll continue. I'm going to continue the case till the date of October 19th, from this date to October 19th as an excluded period.
Thank you, Your Honor. And I'll visit with Mr. Bailey, and then if we have a joint motion, we will then visit with the state to see whether or not these cases need to be transferred to one division or the other for a joint trial.
All right.
And again, Your Honor, so it's clear the state objects to the joinder.
Right. Well, at this point, I'm not transferring it to the other docket and joining the cases. I'm just simply trying to accommodate the request that the case would be available to be transferred if the joinder is in the end agreed to. But there is a certain efficiency in judicial economy in trying two people at the same time. But if it's not agreed to by the parties, then we don't want to. So that's all I'm thinking of, is rather than try to having true trials, maybe we can get away with one, but so I'm just setting it up so that can be done if that gets set up.
Thank you,
All
Your
right.
Honor.
You may be excused, but now stay in touch with your attorney.
Yes, sir.
And your next appearance in court is October 19th
9 a.m.
in this court.
Okay. Yes, sir.
Okay. 2016-224, State of Arkansas versus Joy Lee Seymour.
Your Honor, that is for a change of plea. The plea agreement, this is actually a plea to the court on the amended charge of possession of controlled substance only. And although the plea statement does not reflect it, Your Honor, he is actually entering a plea of no contest to the felony that he is pleading to.
Mr. Seymour, you're appearing here today for purposes of changing your plea, is that correct?
Yes, sir. Yes, Your
And
Honor.
this change of plea is brought about by at least a partial agreement that is by some degree of agreement, but it's the understanding is that you're going to enter a plea of guilty on the amended charges to the court. And we'll postpone sentencing to a later date, and after hearing on the pre-sentence report and other matters, the court will make the decision on sentencing. Is that what you understand?
Your Honor, yes. Well, he needs to answer.
Yes, sir.
And you've discussed this with your attorney, is that correct?
Yes, sir.
And are you comfortable with that, that you understand the agreement and what that means in terms of the court is not bound by any specific agreement in terms of imposing sentence, but
Yes,
has
sir.
the full range of possible sentencing to consider? Is that right?
Yes, Your Honor.
Your Honor, not to interrupt, but he's actually entering a plea of no contest to this instead of guilty.
All right. Let me mark that just so that it's clear. At this point, the arrangements for this, you've discussed, Mr. Seymour, you've discussed these with your attorney, and you understand what you're doing by pleading no contest here today
Yes, sir.
and submitting the issue of sentencing to the court.
Yes, sir. Yes, sir.
Are you satisfied with the advice and representation Mr. Cooper's provided you?
Yes, Your Honor.
On the charge of possession of controlled substance methamphetamine, the remaining charge after pursuant to this agreement, the state has moved to null pros the two additional charges that were originally filed. On the remaining charge of possession of controlled substance methamphetamine, a class D felony, how do you now plead?
No contest.
And all of this is put in writing in this plea statement I'm holding up. Have you read over this plea statement?
Yes, Your Honor.
And you've done this initially and at the end of all these questions that are at the outset of this and throughout, and then you've signed this document, is that correct?
Yes, sir.
And you understand that I have now, as you can see, just holding it up, changed it, wherever it said guilty, I put in no contest, and I've written under, do you understand? There's a phrase where there's a recommended sentence, and I've written in that one, do you understand the prosecuting attorney and your attorney have agreed to submit to the court the issue of sentencing? And you've initialed that, have you not?
Yes, sir.
So I've amended it up to reflect what we're actually doing.
Okay.
And you're in agreement with that?
Yes, sir.
All right. Are you, in entering this plea, do you understand the nature of the charges against you and the full range of penalties you're facing?
Yes, Your Honor.
You understand the rights that you give up when you enter a plea of no contest?
Yes, Your Honor.
The most important right you're giving up is your right to a jury trial. At the same time, you're also giving up the right to be represented by an attorney and assisted by an attorney throughout this process. You're giving up the right to confront witnesses who would appear and testify against you at trial, and you're giving up a right to appeal. All of those are rights you're giving up by pleading no contest. Do you understand that?
Yes, sir.
And understanding what rights you're giving up, are you still willing to enter this plea of no contest?
Yes, sir.
Are you pleading no contest here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion, forced this change of plea to you?
No, sir.
Has anybody made any promises to you that aren't set out in writing in this document? I don't think there are any promises.
No,
here,
sir.
But there aren't any promises that you're relying on?
No, sir.
All right. Based on those statements, the court's going to find the defendant has freely and voluntarily entered his plea of no contest, and at this time will, and after consultation with his attorney, and the court will accept the defendant's plea of no contest at this time, and call upon the state to provide the court with a factual basis for the allegations in the charge of possession of controlled substance methamphetamine.
Your Honor, in July, in Baxter County, Arkansas, members of the Arkansas State Police executed a traffic stop upon the defendant in this matter. As a result of that traffic stop, a search occurred upon the car owned by the defendant. In the process of said search, officers of the Arkansas State Police located in a zippered container attached by a magnet under the seat of the defendant a bag that contained methamphetamine.
Based on those facts, together with the defendant's plea of no contest, the court is going to, at this time, having accepted the defendant's plea of no contest, will find the defendant guilty of the offense of possession of a controlled substance, methamphetamine, a Class D felony. The court will postpone sentencing. Let's see. I'm going to postpone sentencing till May. So the May is the 14th, Dad.
September 14th, Your Honor?
September 14th. excuse me.
Yes, Your Honor.
That's the wrong day. First, I'm going to draft a pre-sentence report will be prepared in regard to Mr. Seymour's case, and ask that report be prepared in a timely fashion and submitted to the court and both counsel, so that we can all be prepared by September 14th.
Thank you, Your Honor.
Thank you, Your
Mr.
Honor.
Seymour, you're directed to respond to the probation personnel that will be preparing that pre-sentence report, so that they can have all the information they need. You may be excused. (2017-28) State of Arkansas versus Bridget Clark.
Your Honor, I think that Ms. Clark is brought back to the court today for a failure to appear that occurred back in May.
Right, this, just trying to review the history. On May 18th, this court called her case and directed a warrant shall issue.
She was extradited back here, Your Honor.
So now, we need to reschedule her on this court's docket. I'm gonna set her for, say her for trial the week of, October 23rd. I'll set her down, a plea deadline date of October 19th.
Triple R, Ron. I did, I talked to him on Monday.
We'll set her down for a pretrial date of September
He told me,
28th.
wait till Thursday when I went to court and then I called.
And have her reappear on September 14th.
Your Honor, Ms. Clark, I understand the state had to bring her back from Virginia. She has been in jail for 30 days or longer. I would ask the court to set some sort of bond. She bonded out through Triple R, and we'd like at least a chance for her to bond out.
We've only had her for about 4 days here. We had to go get her, but we've only had her, she's only been in the Baxter County Jail since I think the 13th.
Right, I was arrested on this charge.
July
In Virginia.
15th, she was arrested in Virginia, Your Honor.
On this charge.
So-
You know, our concern, if letting her out, she's not shown to reappear on her own volition. We have great concern she's going to reappear and be in the same place again, Your Honor.
I've never not this is my first time. My original trial date was the 20th of August. I didn't realize that there was a mid-trial, so I would not reappear again. Trust me.
Well, ma'am, there's good reason you don't understand things if you don't stay around to talk to your attorney.
Yes, sir.
The whole point, we're appointing counsel for you. The attorney is here, and it's the attorney you need to be talking to find out about what's going on in court. We can't educate you, particularly if you leave the state. So I don't have a lot of sympathy for that explanation.
Yes, sir. Can I speak?
Senator, she's asked to speak, and I have no objection. She's speaking only on her failure to appear.
Yes, sir. I had went to my original court date, and I got set up with Mr. Cooper as my lawyer. They told me that he would speak to me 10 days before the trial date on the August 20th. I was arrested July 15th in Virginia on this charge. So I hadn't contacted him. I had every plan on coming back on August 20th for the trial date.
August 20th is a Sunday. I
Or
doubt
maybe
very
it was a-
seriously if that was your court date.
I'm sorry, maybe it was the 21st.
Anyway,
Okay.
the point is you left the state and you didn't show up for court.
Yes, sir.
And if you don't understand that you're supposed to be in court, then
I didn't know it was.
I can't do very much to help you.
Yes, sir.
The previous bond was $10,000. I'm not going to even consider something like that. I'm gonna set bond at $50,000. That'll be a cash or professional bond. She's been given her trial dates and we're gonna proceed on that schedule. You may be excused. And let's see, we can't do 2016 366 State of Arkansas versus Robert Dixon.
Judge, this is another district appeal. Come on up, Mr. Robert. This is just one that we'll agree to try to the bench. We just need to pick a time to try it. It's an issue that I think will take an hour to try. I think it's a 1 or 2 witness case at that.
Are we prepared to have a waiver of jury trial?
Judge, we are, and I thought I'd had it in the file, but I didn't see it. I'll get Mr. Dixon in to sign off on a waiver of the jury trial. I'll see if we can't do that
let's do that and then.
End of
let's
this
set
week, early next.